Okay, you have already created a transfer on death designation under your plan. Now what? If you have been following us for a while, we've talked about the critical risks, potential pitfalls of a transfer on death designation under property or accounts. We want to address how you treat that if you already have it. I'm 𝗪𝗵𝘁. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you need help creating your estate plan or administering an estate after the loss of a loved one, we'd be happy to help. You can reach us for free consultation at yourplanningattorney.com. And you know we're here to educate all the time, so ask questions and share so together we can help some folks along the way. Now, outside of the assets you may own in an irrevocable trust of some kind for a specific benefit, you can change the ownership and beneficiaries of your accounts at any time. They're your assets, right? And yes, a TOD or transfer on death does avoid probate because it goes to that beneficiary you've chosen, but it misses out on so many other added layers of protection, privacy, and control that could be found with a proper estate plan. Let me give you some examples. If you choose instead to transfer your bank account, let's say, into a revocable living trust, then your named trustee after you can get access to that account immediately upon your becoming incapacitated. So bill paying, insurance, taxes, all the things can be taken care of in a seamless way. No hiccups. That's not the case with a transfer on death because you still own it individually. So what do they have to resort to? Your power of attorney, should you have a valid power of attorney, they would need to submit it to the bank, get it accepted, which can be an uphill battle, even if there's just a few years age on that power of attorney, and then take charge, assuming that it gets through. Plus, with a trust, you can implement additional protections for your beneficiaries. For example, again, you can have creditor protection for each of your beneficiaries. Let's say your kids. Wouldn't you want them protected from any kind of lawsuit of any kind, whether that's an accident, a professional malpractice, or a divorce situation? You can do so through a proper estate plan, not a TOD designation. And what about if, God forbid, that beneficiary predeceases you? The TOD does not account for this and have all the backup what ifs covered. That's where an estate plan comes into place. So please, please, please speak to a proper estate planning attorney, talk through your wishes, talk through your goals, and maybe even some of the things that you hadn't thought about, which the counsel can bring up and address for you to protect you even more. Again, I'm Valerie Zammitti. We hope you've learned something new here today. Don't forget to share and take care. Bye-bye.